Immigration fam. All right. Good evening, immigration fam. Hope everyone's doing great. We have another live. So if you are having dinner or you're done with dinner, please feel free to join me so we can talk about something that I think will be of value to anyone who joins this live. All right. So I'm going to introduce myself for those who are joining me for the first time or those who do not know me. My name is Ifama Odunlami. I'm an immigration attorney from the Odunlami law firm in Cedar Knolls, New Jersey. We work with clients all over the world, all over the 50 states who are looking to build a life here in the United States. Our passion and our mission is to help our fellow immigrants live here without fear of being deported, without fear of being separated from their families. All right, so talking about families, I want to talk about family-based immigration. What is family-based immigration? I want to talk about the four most common mistakes that people make that can endanger their family-based immigration. And you know the sad thing about this is people who file this paperwork, they're not aware of it. So they never become aware there's a mistake or there's an error until it's too late. So by coming on this live today, I want to help somebody who's filing their paperwork to avoid making this mistake. And the reason is because, sometimes family-based cases can take a really long time, sometimes 5 years, 7 years, 10 years, 15 years. You don't want to go through this process to find out that you've made a mistake that basically would deny you your ability to get legal status here in the United States. So that's why this topic is right on time. Let's talk about it, okay? So I typically will give my topic and then answer a couple questions. It's a little late today, so I probably won't be answering a whole lot of questions, but let's talk about this very important topic. So for starters, I want to talk about what family-based immigration is for those who do not know. Family-based immigration is a process through which a family member who's a U.S. citizen or a green card holder can file for another family member and bring them into the United States, or if they're here in the United States, allow them to get their green card through that familial relationship. So there are two different pathways. There is a pathway through the immediate relative category, and I'll discuss what that is. And then there's the pathway through the family preference. So the immediate relative is if you are the parent of a US citizen who's under the age of 21, if you are the spouse of a US citizen, if you are over 21 and you're a US citizen and you file for your parent. These three categories are called immediate relative petition. And basically what this means is that you can file for these family members that I talked about without having to wait for a visa to become available. There's no line that you need to wait to get to filing when, waiting for a visa to become available. Now, of course, there's still a process which takes time. And of course, if you're filing for this process outside the United States, you as a US citizen, you're filing for your spouse outside, you're filing for your young child outside the United States, or you're filing for your parents outside the United States. It typically takes longer than if the person were here in the United States. But there's no waiting for a visa. So you basically are just waiting for it. The wait time is the process. Now, there's a family preference. And under the family preference category, there, I would say 4 main categories, but one of them is broken into 2, and I'll tell you which one it is. In this family preference, there's no visa just available at the time of filing. You have to wait until a visa becomes available for you to proceed onto the next step, all right? So typically you file your I-130, that I-130 becomes your priority date. That's basically the date where you're on the line, and that's the date that they look at to determine whether a visa becomes available to you, all right? So under the preference, there are 4 types. there's the single unmarried child of a US citizen over 21, right? That's F1. F2 is divided into 2A and 2B. F2A is a green card holder filing for a spouse or a child under the age of 21. F2B is a green card holder filing for an adult child, which is a child over the age of 21, single or married over the age of 21. A green card holder cannot file for a married child, okay? Then F3 is a US citizen filing for a married child, right? And then F4 is a US citizen filing for their siblings. Now, that F4 is the longest category. That's the one that can take up to 15 years, 20 years, depending on what country you come from. So now you know this categories of, pathways where you can file for your family member. So I want to talk about the 4 things that can get you in trouble, that can stop you from getting a green card based on a family-based filing. And these are errors that people make without realizing them. And I want you guys to know this. And if you have family members who are trying to file for others, you want them to know this as well. All right. So let's talk about number 1, stepchildren petitions. Immigration recognizes the step relationship, right? They recognize that a US citizen could be married to a green card holder, could be married to a spouse who already has a child. And that relationship is recognized, like I said, by immigration. However, a step-parent or a stepchild can only file for their step-parent or stepchild if the step relationship was formed before that child turned 18. That meant the biological parent and the step-parent got married before the child turned 18, not on the 18th birthday, before the child turned 18. And if that's the case, then a petition can be filed. But if there was a marriage after the child turned 18, then even though it's a step-parent relationship, it's not valid for immigration purposes, which means that immigration would not recognize that as a proper relationship that the step-parent or the stepchild can file a petition to get their family member a green card. All right. Now, this destroys many cases because people don't know that age 18 is a cutoff. So get married before the child turns 18. All right. That's mistake number 1. Now, mistake number 2, I can bet you a lot of people don't know this, right? I'll give you a context. So let's say John's brother, Sam, filed for John under the F4 category, right? And I've told you before, this category takes a really long time, 10 years, 15 years, a while, right? So Sam is a US citizen, he files for John, and because he files for John, who's his brother, John can bring his wife and John can bring his children under the age of 21. And so they go, the petition goes through, they go to the embassy, they get the approval to, for the green card. And you're not considered a green card holder until you're inspected, which means you come through the border, Customs, Border Patrol, they inspect you, they allow you to come in, and you come into the United States. That's when you're considered to have gotten a green card. Now, many busy people would be like, oh, you know what? I'm trying to wrap up my business. So John would be like, you know what? I'm trying to wrap up my business. Let the children and my spouse go first. I will come later. That's a big problem because the primary applicant must be admitted at the same time or before the derivatives. The derivatives will be John's wife and John's children. They're not the primary. They only got their pathway through John because John's brother Sam filed for John. And because John is under F4 category, John is allowed to bring his wife and his children under the age of 21. But if John doesn't get inspected and admitted into the United States first, that's a problem. And a lot of times at the border, they actually will not let them in. But if a mistake happens, and I know we had a case such as this, where for some reason they let the child in before the parent. I think CBP didn't realize it, or I don't know what happened. The child comes in, has a green card, but cannot naturalize. All right, because that green card was gotten improperly. So if you are the primary immigrant, you must be admitted into the United States before or at the same time as your derivatives, okay? Important, all right, because a lot of people do not know this. So the third mistake that people make that can, who's not hearing me? All right, somebody on Facebook says they're not hearing me, but can you scoot over to Instagram or to YouTube, because I don't know what's going on. So the third mistake that people make is changing your category that you were filed for. I'll give an example, because this happens a lot. I cannot tell you how many times this happens, right? And this mistake can get you deported, even if you have a green card. So I'll give you another example. So let's say Mary's father filed for her under F1, which is single child, single adult, right? And Mary goes to the embassy, she's approved, she gets ready to come into the United States. And then Mary's boyfriend says, you know, how do I know you're not going to forget me when you get to the United States? You know, I don't know if this relationship is going to last. So I feel like when you leave, that will be the end of us. So Mary now wants to reassure her boyfriend that, no, this is not the end of us. I'm always you are my heart. And once I get into the United States, you know, I'm going to come back and we're going to get married. And he's like, no, this is it. And she wants to give him some comfort. So she gets married to him just before she leaves to come into the United States. And she comes into the United States, but she doesn't indicate to anybody that she got married after she was approved for the green card. And she comes in as a green card holder. And then she tries to naturalize. And she fills out the form. She says she's married. And at this point, she's thinking, you know what, I'm going to file for, you know, my boyfriend. And then the officer says to her, when did you get married? Did you get married before you came into the United States and were admitted as a US citizen? And she says, yes. That's a problem. She cannot naturalize. And depending on the officer, she might be put in removal proceedings to lose her green card because she was filed for under F1 as a single child, and she came in married. Now, the right thing for Mary to do is to come in the category she was filed for, which is F1, come in, and even if she comes in and the very next day, as soon as she gets into the United States, the very next day, she turns around and flies back and marries her boyfriend, that would be okay because she was inspected and admitted as a single person, which was the category which her father filed for her, F1, right? Yes, Bertha, it's always written on the visa, but some people, for some reason, don't realize it because maybe some people don't read what's on the visa. I don't know. All right. So that's why it's important, because it's happened a couple of times. We've had cases where the principal came after the beneficiaries. And most times they stop them, they don't let them come in. But one, or it was a couple of cases, for some reason, CBP missed it and they let them in. All right. Now, similar to that, I'm going to talk about derivative asylum. This one is a common mistake, right? So this person, a parent who has asylum, got asylum status, had derivative children who were derivatives, and so they were also asylees, right? Now, if you have derivatives from your asylum status, if you get naturalized without your derivatives adjusting their status, they're not going to be able to adjust their status. I mean, there are exceptions, and sometimes attorneys, we had a case like that. We had to file something called a non-protonc, which was basically telling USCIS to just pretend that this filing was done when the principal was an asylee. But when the principal asylee naturalizes without the derivatives adjusting their status, that's a problem too. That's a big problem, because what happens now is the asylee status is what gave the derivatives their derivative asylee status. So when that's gone, they have nothing to derive. They cannot derive that status anymore, and it's gone, right? So you want to make sure that the derivative, before a principal asylee holder applies to become a US citizen, applies to naturalize, you want to make sure that the derivatives have entered the United States and, to be safe, have adjusted their status. All right. So these are 4 ways that people have lost their ability to get green cards, based on just not following the rules, not knowing the rules, not realizing that there are little quirks in the rules. Okay. So I'm going to take some questions, but if you know somebody who's filing their petition, you want to make sure that, you know, forward this video to them, okay? Because we hate it as attorneys. I can tell you that it is so painful to have somebody come and you say, oh my God, this little mistake you made, that's it. I know this young man who, his mother filed a petition for him under, I think it was F1. And he'd been waiting 7-8 years, and then his priority date was current, and he decided to put in the petition, and guess what? He had gotten married. Boom, that's it. The portal was closed again. Now he has to wait, because now he's under a different category, right? And luckily for him, his mom is a US citizen, because if his mom was a green card holder when he got married, that's over, because there's no category for a green card holder to file for a married child. So if you have any questions regarding categories, what you can do, you should talk to an attorney, because waiting for a long time to get your green card and finding out that you made a little mistake that sends you back to the beginning of the line, or basically revokes the pathway that you were on, is really painful. You're losing money, you've lost time, and just knowing that everything you've hoped for and dreamed about has just crashed is really painful. So you want to make sure that you are consulting with an experienced attorney, because some people will consult with this notarios or form fillers that can fill out forms, but they don't know the rules behind the forms they're filling out. Okay, so let's answer some questions and then we'll call it a night. Alton Bell says, I did 2 separate biometrics, one for I-485, 765 for 360. How long can I expect my EAD? Alton, you know, this EADs, work permits, travel permits, the timing is just, nobody knows anymore, but it's taking a little while, okay? I think on an average, I would say 7 to 9 months, but sometimes some people get it earlier, some people get it later. I really can't tell you, because it's really all over the place, okay? All right, let's see. I'm gonna go on, let's see if there's any question on TikTok. So Linda Ikeji says, can I travel out of the US with no criminal record as a green card holder? Yes, you can, but it's not just criminal record that could cause you some problems. If there was any issues, as we say in Nigeria, there's any comma to this green card. Maybe they sent you annoyed, you didn't have this, you didn't have that, or sometimes even your travel partner could put you in trouble if you're traveling with somebody who is not, maybe you got your green card through marriage and you and your spouse are no longer together and you're now traveling with somebody who is not your spouse, and USCIS thinks, immigration thinks there was some cheating involved by you, that could be a problem. So you can travel as a green card holder, but the truth of the matter is, in the past, it wasn't a problem. Now at CBP, nobody's clear about what rules they're following. But if you're very sure that you have nothing that you should worry about, then it's up to you to take the risk. I personally have been telling people, really, I'm risk averse. Don't travel unless you absolutely have to. And if you do, then talk to an attorney and just make sure that you're upfront with every single thing that could, possibly be raised. And for some people, there are things that they're not even aware of. Sometimes it could be that arrest 20 years ago that the case was dismissed. We're seeing people being, put into immigration proceedings because of old arrests. But it's really up to you. People, green card holders are traveling in and out without a problem, many of them, so it's really it's really fact specific, okay? All right, let's see. Big Resty says, when a mother files for married son, how long does it take? It takes a while. You should look at the visa bulletin. Look at the visa bulletin. Today, this is March 2026. Go to F3. Depending on what country you're from, it will tell you what cases they're working on. Now, you don't exactly know how long it's going to take, but you can guess that, if they're working on cases that were in 2016, that were filed in 2016, it's going to take a while, but I do know that F3 is taking a really long time. I just don't know how, I don't remember how long. All right, let's see. So Dorothy says, is the EAD still issued through the marriage-based green card for people from the banned countries? Well, what we're hearing right now is that if you're from one of the travel ban countries, let's start with the 39 travel ban countries, they're not giving any immigration benefits, which includes a work permit right now. But they did say they were going to review all their processes again, and we don't know when when the ban is going to be lifted. We don't know when they're going to start the process, giving the immigration benefits. I do know there's a lot of lawsuits out there, and we'll see if any of them, are helpful to this travel ban situation. All right, guys. I think those are all the questions I have. So a pleasure talking to you guys. I was supposed to come in on Tuesday, but yesterday I was busy. So I'm going to try again on Thursday because I try to do my lives on Tuesdays and Thursdays. But until then, have a good night. Take care.